The window for legal documents closes a lot faster than people realize. If your parent is starting to forget appointments, repeat stories, or get confused about money, your planning window may be a lot narrower than you think. I'm going to tell you what to do this month, not next year. First, I want to start by saying everything you're going through right now is incredibly difficult, and I know that there's a lot of weight on your shoulders to help navigate affairs for your parents. It can be easier. We just have to start the process as soon as we possibly can. If you're already in this situation, the conversation is actually going to be a lot more helpful than any video can be. Click the link below. To create a binding estate plan with legally effective planning tools like powers of attorney and last will and testament, the client has to have general awareness of what's going on, but they don't have to have perfect cognition. The bar is actually lower than it may seem. The person generally needs to understand who they are, what they own, who their beneficiaries are or could be, and generally what they're signing. They don't have to have perfect memory of yesterday. They don't have to have perfect recall of their entire lives. They have to understand those things right now at the moment of signing. We're faced with the opportunity to plan for someone whose cognitive ability is waning. We want to prioritize certain things now before it's too late. Durable financial powers of attorney and healthcare powers of attorney are going to be critical to get in place before that person loses capacity. This is us trying to harvest authority or harvest control of their affairs before it's lost forever, or before it can only be regained through court-ordered guardianship. Once we have gotten powers of attorney in place, we want to think through our legacy, our things like wills and trusts and titling, to make sure that things are where they need to be to benefit the right people if you were to pass away. But before any of that, the powers of attorney are crucial. They're our ability to coordinate the day-to-day meaningful affairs of a loved one. You need an experienced estate planning attorney to make sure that these tools are done right. Click the link below to start the conversation. Powers of attorney are generally going to be more impactful and more important than a will in this scenario because the powers of attorney are how we take care of our loved one while they're still here. A will just says what happens after they pass away. The powers of attorney allow us to pay for their bills and expenses, maybe relocate them from one residence to the next, consent to different health procedures and care that they may need, and can't really coordinate on their own. Without powers of attorney in place, the only remedy that is available to a family member is to go seek guardianship from a court where your loved one lives. And that process can be expensive and slow and very burdensome in process to get accomplished. But of course, this is not an easy conversation to have with our parents, the people who raised us and have always felt a need to assist us. Now the roles have reversed a bit. We want to lead with control and comfort, not taking control of someone, but maintaining their control to be able to make choices that they otherwise would have made for themselves after they're no longer able to. We want to completely avoid any sort of accusatory language like you're losing your mind or you're going crazy or you can't handle things by yourself. We want to always frame things in assistance, advocacy, and their wishes, making sure that we can maintain all of that no matter what the future has in store for us. But if it's already past the point where we're able to do anything proactively, where your parent or loved one no longer has the capacity to understand who they are, what they have, who they want to benefit, and what documents they're signing, then our sole remedy is to petition for guardianship with the clerk of court where your loved one lives, in the county of their residence. We ask for the court to evaluate different circumstances and facts to make a determination that your loved one no longer has capacity and is legally incompetent. Once that determination's been done, then the court can appoint a guardian to exercise that person's rights in their absence of their ability to themselves. This process can take several weeks to get onto the court's calendar to have the hearing. It involves a guardian ad litem who's going to make sure that they make an independent assessment of the needs for your loved one. And then the court will ultimately make a determination on their own after all of the facts are known and the hearing has been had. This process can often take several months to get done, depending on what county you're in and how many other cases they're working on. But there's 3 immediate steps to take if you're watching this and maybe a little bit worried. The first is to schedule a consultation with an estate planning attorney this week. Second is to schedule a capacity screen with your loved one's primary care physician. And the third is don't wait until there's more decline. I know this is hard, it's uncomfortable, but the families that we see succeed act before it's too late. The link below is to start that conversation. Protecting your family requires more than just standard documents. Schedule your consultation with our team today.